Moving on to the RQ, the Rekieta question. Except this time it's not, well, it's tangentially related to Nick. It is Kayla. If you guys remember, we've already covered Kayla's motion that it was drywall dust. Or it could have been, Nick could have been on Ozempic. That is Kayla's argument. Well, the prosecutor got a chance to respond, and oh boy, did she respond. Now, it hasn't been denied yet, but this is kind of just a precursor for what we're doing. And this is the state's response and opposition. Now, it's very funny because there's one big problem I have with it, and we'll get to that when we get there. And they say this, and this is the state's memorandum of law in opposition. So they're opposing it. And the sole issue before the court is whether there's sufficient probable cause to support the search warrant. And obviously, they want the court to deny Kayla's motion in its entirety. Now, once again, the U.S. and Minnesota Constitutions provide that no warrant shall issue without a showing of probable cause. And they have their own Minnesota Supreme Court case that reflects on the 14th Amendment and the 4th Amendment. In determining whether or not the warrant is supported by probable cause, the issuing judge's decision is not reviewed de novo, meaning it's not reviewed in its entirety. And instead, great deference is afforded to the judge or magistrate's findings of probable cause. And that's true. Generally speaking, they pretty much are considered to have made the right decision. There's a lot of deference given. And they say to determine whether the judge had a substantial basis, we look to the totality of the circumstances test. And that goes back to Illinois v. Gates. Remember, guys, we talked about this before. There were two tests out there, the Aguilar-Spinelli test and then the Gates test. The Gates test is the predominant one in the United States. There's only 4 states or 4 or 5 states that do the older, more restrictive approach to getting a search warrant. And they say in determining whether there is probable cause of search, the issuing magistrate's task is to simply make a practical, common sense decision whether, given all the circumstances set forth in the affidavit, there's a fair probability that contraband or evidence of a crime will be found in a particular place. So they talk about this. The courts must ultimately be careful not to review each component of the affidavit in isolation. And that's true. You have to look at it in its entirety. Think of it like a cake. You know, I would use the sandwich analogy, but you could pull the pieces of a sandwich apart. But once you bake a cake, you can't separate out the eggs. You can't separate out the flour. You can't separate out anything. It's all one thing now. You have to look at it in its entirety. Does it make a cake? And they say a collection of pieces of information that would not be substantial alone can combine to create sufficient probable cause. Well, it's like we talked about that. And, you know, she's showing case law that says that, but it's like I've said that before. You know, 1 brick is a brick. 100 bricks is a wall. And the warrant should not be invalidated by construing the affidavit in a hyper-technical rather than common sense manner. Yes, you know, that means sorry out there. If you're trying to act like you're on Reddit and go, well, actually, what does that mean? There could have been a watermark. What do you mean you saw the originals? No. Sorry, it doesn't work like that. It doesn't work like that. Now, I don't like this part. Doubtful or marginal cases are resolved in favor of upholding the warrant. I think that that's actually a problem. I think that, you know, there should not be the burden given to the person finding. I think it should be tough. I think the Aguilar-Spinelli test is far more effective at protecting liberty interest. So this idea that doubtful or marginal cases are resolved in favor of upholding the warrant, doubtful or marginal cases should be resolved in favor of the person who's going to have their shit searched. That's the right way to uphold that. This right here, I think, is just, obviously a court's never going to agree with me, but I think this is actually a bullshit idea. Now, the warrant must supply specific facts to establish a direct connection or nexus between the crime alleged and the place to be searched, particularly in cases involving the search of a residence for drug activity. And they say direct observation of evidence of a crime at the place to be searched is not required, meaning the cop doesn't have to sit there and peep in the window and see the drugs. The nexus may be inferred from the totality of circumstances, including type of crime, nature of the item sought, extent of the defendant's opportunity for concealment, and normal inferences as to where the defendant would usually keep the items. And once again, well, you got drugs, you might keep them in your thing. Now, they say a finding of probable cause may rest upon evidence which is not legally competent in a criminal trial, and that's true. You can have hearsay. You can have completely inadmissible hearsay. You can have hearsay that's double hearsay. As long as it's reliable, it can still be used. Now, you would have problems about introducing hearsay at trial, but remember, you get a little bit of leeway because otherwise the police would never get anything done. Now, some of you might say that's a based idea, but the court's never going to let us get there. Once again, it's like getting machine guns. We're never getting them. Officers may rely on their training and experience to draw inferences, and the reviewing courts may only consider the information in the application for the search warrant. And the neat thing is, for Kayla and Nick, we have the application for a search warrant from Detective Pomplin. So we've got that, and we're going to go through that again. Now, they start off, and here's where it starts picking up. The affidavit for the search warrant begins with a child maltreatment report that was taken by Sergeant Nestor relating to controlled substance use by the defendant's husband. Once Detective Pomplin received the report, he began an investigation into whether or not there was criminal activity related to drugs. The name of the reporter or the relationship was not included in the affidavit. Now, this is great. However, the name of a reporter of child maltreatment may not be disclosed. Oof. Remember that the whole time. You're not telling who did it. State law doesn't let you. Ah, no. Oof. Oof, chat. Your laws and your rules, you got to follow them. You got to know them. The report was the basis of law enforcement's investigation. Yes, it was. It was not the entire investigation, nor the sole basis for the application of the search warrant. And it's this part here. Kristen Pierce, if you're out there and you know from the Kandiyohi County prosecutor's office, just if you're out there, I appreciate this. Even if the court were to strike the information about the child maltreatment report from the application, there is still probable cause for the search warrant based upon Detective Pomplin's investigation. Oh, damn it, it didn't switch over. Hold on, chat. Here you go, chat. That is right there. Ooh. If the court were to strike the information about child maltreatment from the application, there's still probable cause. Ooh. The funny thing is, it's like I've mentioned that before. It's like I've said that before. Just like, based on my experience and practicing and figuring things out, it's like I kind of knew this. It's like I kind of already said this. It's like great minds think alike. And here's the thing. I'm not even thinking as a great mind. But once again, chat, let's get back to this. Let's get back to this and see where Nick's going to probably claim she's absolutely bullshit lying off. Here's the application for the search warrant. We don't need all the preambles because that's not important here. The case background, this is where we're going to start. That's where we're starting. Let's see here. Oh, we got to make that very opaque. So on May 16th, Sergeant Nestor received a report of controlled substance use. Okay, so Sergeant Nestor received a report about possible controlled substance use. The reporter indicated that Nick lives at his house and with Kayla, and he lives with Kayla, and will remove the children. The reporter indicated that 4 people from the church had gone to him reporting possible controlled substance use and a questionable relationship with an adult couple. See, look, we're already weaving our way through this, and you could start thinning stuff out. That's where we're going. See how easy it is? You can remove those things. Like, I know Nick likes to play Mad Libs. Like, unlike Nick, honey, unlike the Bible, this is where you actually do that. Can you remove things and still get the right outcome? Now, let's get through this. So let's keep going. Let's keep reading here. So it was reported that Immels may have been staying in the home with the Rekietas, and the home was in disarray and cluttered. Okay, perfect. It was reported from a church preschool teacher the children had complained about not being fed. Okay, and yeah, we'll remove all that 3 or 4 days at a time and would start to smell. Getting rid of it. And then here it's just the comments about Nick looking like a lush, looking like he's doing the yayo of some sort. Pure higher drug driving a car around, that Nick would walk out of sermons randomly. Kayla is looking really bad too, and they seem to look like they've lost a lot of weight. Yep. So there you go, chat. Notice we've removed that. You can still figure stuff out here. So they talk about reviewing the blogs. Doesn't help, nothing we have to cut out. Don't have to cut out anything more there. It's apparent, we keep going here, and we'll even take out the stuff involving Aaron's kids. Imhold indicates in this blog that Nicholas needs help and needs to get help for his kids because of the substance use. See, look, there we go. We're eliminating all the stuff about kids. We're just getting rid of all of it, chat, and it's just going to be, you can get rid of this, like, follow along with me. We're going to do like Bob Ross style. You know, happy little redactions. You can go along with me here, and you'll see it works, because now we're into Nick riding the white stallion, doing that booger sugar, just chugging down that cocaine with his nose. And notice, now we don't have anything else there regarding the children, okay? So your affidavit's requesting the search for the above listed items in relation to the welfare of the children, and then we'll skip that, in relation to a controlled substance investigation. Your affidavit is also requesting to search Nick. See, there you go. See, look, I removed all the stuff about the kids, chat, and look how much we got rid of at the end of the day. Look at this. This is not that much. We're going to zoom out here. How much do you think we got rid of? Just bits and pieces. Just bits and pieces. So that's why, once again, it's not a hard thing to come in here. And look, we've already deleted bits and pieces of things. And look, all gone, all done. Took all the shit out about kids. Like 1 sentence, 2 sentence, 3 sentence, 4 sentence, 5, 6 sentences total. 5 or 6 sentences total, and that's what Nick, they're all crying about. Like, see, we got rid of it all. We got rid of it all. I got rid of all the mentions of the children. Done. Does it still look like a pretty substantial report? Yeah, it is. It is. That's because it is. Less than a paragraph of over 3 pages. Yep. But don't worry, guys. The prosecutor is not done. The prosecutor is not done. So Detective Pomplin went on to review the social media of the defendant's husband. These videos are available to the public. They are. Detective Pomplin noted a dramatic change in Nick's appearance. He lost weight, appears tired, and overall appears strung out, which is common for drug users. These videos were recorded in the home of the defendant. Yes, once again, do not document yourself committing crimes, chat. Detective Pomplin also reviewed the social media of Aaron Imholt. In his videos, Imholt talks about experimenting with cocaine and other substances. There are no direct statements by Imholt the defendant was using drugs. Pomplin pointed out that Imholt insinuated use by the defendant, but not directly state that. And that's fine, because the inference can be drawn. In the application for the search warrant, Pomplin notes there was a pre-existing relationship between Kayla and Aaron by referring to their prior videos. And they say Detective Pomplin included there may have recently had a falling out between Aaron and the Rekietas and Kayla. He also indicated that Aaron and April had separated. Pomplin informed the issuing magistrate that April and Kayla were no longer on good terms. Don't worry, Nick is going to force you to live together. Aaron also talked about a video where Kayla appeared to be under the influence of a controlled substance. And they say Pomplin did not rely on that statement alone, and he didn't. Detective Pomplin watched Nick Rekieta's video for himself. Detective Pomplin has been trained as a DRE, where he has received specialized training to identify the signs and symptoms when someone is under the influence of drugs. Based on a review of the video, Pomplin stated the defendant was showing signs of being under the influence of a controlled substance. While Pomplin could not perform sobriety testing, he is able to recognize the physical signs of being under the influence of drugs. They are observed visually, and they can be observed in the person and through videos. Yeah, I mean, it's very much, like, oh, she's walking through, like, oh, I'm good. It's just like if you get really drunk, chat, you think, oh, I'm the toast of the town, and everybody loves me. When in reality, you're blackout drunk and just acting, you're like, ah, let's do a keg stand. That's, everybody thinks that, everyone thinks there's somebody who's refined and acting like they're in the New Yorker. No, when you get blackout drunk, you're a lunatic. That's all of us, though. That's a human condition. She keeps going to discuss other things here. The judge just has to make the practical common sense decision. They do not have to prove beyond a reasonable doubt the subject of the search warrant is guilty. And that's true, because even if you could do that, there's been no opportunity for him to defend himself. Probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of such activity. The significant fact not being whether particular conduct is innocent or guilty, but the degree of suspicion that attaches to particular types of non-criminal acts. And it's true. If you're hanging out and looks like you're looking a little sketchy, and you're playing with a lockpick on a bridge, trying to get play with a bridge full of locks. That's one thing. But if you're creeping around an office building in town in the middle of the night, yeah, that's going to look a little weird if they see you playing with the door. And I say, thus, innocent or non-criminal activity can contribute to the totality of circumstances on which a finding of probable cause is based. And that is true, and that's a sad part about it, but that can happen. Now, cops may rely on training experience to draw on their affidavits. Pomplin relied on a specialized training as a former drug recognition expert. That's a bit of an issue, though. Now he's a former drug recognition expert. Well, how long ago were you a drug recognition expert, Pomplin? Because it says your prior 15 years as a law enforcement officer, but how long has it been since you've taken the class? Have there been changes? I don't know. Have there been big changes in the drug recognition world? We don't know the answers to this. We don't know the answers to what's going on here. So I have a bit of an issue. How long was he former? We don't know the answer to that yet. And say, based on training and experience, including looking at pictures of people and their pupils, he was able to articulate the signs of controlled substance abuse he observed in Nick's videos. Even a layperson could have done that. Even if there was an innocent explanation for some of these indicators, that does not negate Pomplin's training and experience and deductions he's able to make based upon those indicators. Now, his subsequent investigation and personal observation of Nick and his videos corroborated the information provided to Deputy Nestor about the ongoing substance use in the home. And that's true. And as I said, guys, the information you learn later in the case, in this situation, does turn around and vindicate and corroborate the information they received right off the bat. And they say the totality of these facts establish a direct connection between drugs and Kayla's house. Even if this were marginal or doubtful, the Supreme Court has mandated that resolution of such cases should be largely determined by the preference to be accorded to warrants. Still hate this. Nope. Do not like it. Do not like it. Do not like it. It should not be how it's done, but it is what it is. They talk about, once again, great deference to the magistrate's determination. And they say, with this in mind, the search warrant application taken as a whole demonstrates the issuing magistrate had a substantial basis for conducting the probable cause existed to support the search warrant. Yep. And they say with the application together, in a practical common sense approach, there is a substantial basis to conclude that contraband or evidence of controlled substances would be found in the defendant's home. So they say, therefore, the motion challenging probable cause should be denied in its entirety. And signed by Kristen Pierce. Remember, guys, Nick was saying she was still learning how to use a computer. She's doing pretty good now. I'm just saying there, Nick. Just saying there, buddy.